Here I am to talk about assessment around the world. First of all, I want to say some few words. First of all, of thanks, actually, to IALS, in particular to Rebecca and also to Ali for the invitation to come out here. It's absolutely amazing, and I love being here and talking to you guys about legal education, hearing what you're doing as well. I was afraid that some of what I was going to be saying might be kind of teaching you to suck eggs, but we'll see where it goes and where it takes us anyway. What I like to do is to present some examples of what people are doing around the world and focus it particularly on experiential learning too, and build in innovation, as it were, just to give you some ideas of what is possible and what is being done in other jurisdictions and possibly also other disciplines as well. Very, very quickly, a kind of overview of what we're going to be looking at. We're going to be looking at, first of all, what exactly is challenging about this sort of thing. You've already been doing this, actually, today in great detail, but I think we can maybe look at some other little aspects of that. Also adapting from other disciplines, from other jurisdictions, and then what I call extreme law school teaching and learning. First of all, looking at the hegemonies, very often what you find when you're kind of looking at teaching and learning is that the conventional teaching and learning kind of constrains you, as it were. It certainly constrains you as far as the assessment is concerned. And this table here kind of sets out some of the constraints. So if we think of learning, for example, as being teacher-focused, then very often your assessment will be teacher-centred, not learner-centred in lots of kind of significant ways. And we'll be looking in a moment or two at ways in which assessment could possibly be more learner-centred rather than teacher-centred there. I won't go through all of those points there, but you see the sort of issue there, that there is very often an alignment between what we do in learning and teaching that feeds into the possibilities or the constraints that we create for ourselves in assessment. And Lee Shulman put this, I think, really succinctly in the Carnegie report, which you all know about, when he talked about signature pedagogies. And I think that we could maybe also talk about signature assessments, as it were, signature forms of assessment as well. But what he was talking about when he was talking about signature pedagogies was 4 characteristics. I've put them into a kind of into a grid there, but it looks static. But actually, Shulman was very clear that these are always in tension with each other. I think that's really interesting because they're they're not free-floating, they're not static, but they're in tension with each other. What are in tension? The surface structures of the pedagogies, the tacit structures, the values, dispositions, the deep structure, and my favourite, which is bottom right there, the shadow structure. The shadow which is always there, kind of waiting to emerge, but which is kind of dominated by the normal forms of teaching, learning, and also assessment as well. And what I try to say in this book here, Transforming Legal Education, is that we actually need a new view of these sorts of things. So, for example, we need more experiential learning, top left. We need much more emphasis on ethics in the curriculum. Bottom left, we need a focus on technology that we can use for our discipline in our law schools, rather than to be constantly adapting other people's or indeed general kind of higher education pieces of software, and that we can do that for ourselves. Cali, for example, does a brilliant job of that in the US, and I dearly wish that we'd have a body like Cali, in the UK or even in Australia for that matter as well. You guys are quite blessed by having that body there amongst you. But also, and in a sense, this is in many respects the shadow. Collaboration between students, institutions, academic professional learning, and also open access cultures. And if we look at how that pans out in one particular form of assessment, I'll take you through that if you kind of bear in mind all those characteristics there, or at least some of them. We'll look at one called Standardised or Simulated Client. The methodology goes by both names. And basically here, it's quite simple. What we're trying to do is to train lay people, not law students and not lawyers, but lay people, to do two things well: to represent a scenario to the lawyer, but also to assess the client-facing skills of the lawyer. That's quite important and quite significant as well. Very often we use actors, for example, for interviewing, but the assessment is the important thing here. Where did we get this idea from? Well, there were originally 4 of us involved in this, myself and my colleague at Strathclyde, then Karen Barton, and of course Clark Cunningham from Georgia State, and Clark's colleague Greg Jones was involved in this with us as well. We looked at medical education here. Ton of literature, absolutely amazing stuff there, where they are used as standardised patients. Why are they used there? Because effectively the training doctor can learn so much more about the patient care, patient handling skills, and the patient-facing skills by actually doing so with the real-life patient. So basically what we were doing was asking these sorts of questions here. Could we transport all of that literature, all of that understanding, as it were, over half a century worth of critical and research literature into law, and do the same for law, and make it a kind of standardised client project? We also had to ask other questions. For example, is it cost effective? And also, is it reliable, valid as well? That was really important for us, because there's no point in assessing something carelessly. There has to be a methodology there. There has to be some kind of an output as well. Well, what was really interesting about it was that we proved that it could be, and we did it by doing a correlative study. So at Strathclyde, we had about 250 or so students then. We trained our tutors according to the same methodology that we trained our standardised clients. We then assessed the standardised clients against the tutors, amongst other things in this study, the details of which you have up there. In addition, we also got the students to the clients to assess the students according to a questionnaire which was validated with practitioners and academics at Strathclyde via something called the Delphi method. And that questionnaire has been the basis for our work subsequently. Really important that you do validate it in that sort of a way. The questions were only 8 in number. And they started with, client greeting and so on, with the final question being, if you had a new legal matter, would you come back to this lawyer? Answering all of them on a 5-point Likert scale. So basically, we found that the use of our standardised clients was as reliable and valid as our tutors' assessments. So now at Strathclyde, and ever since then, that was 2006, we don't use tutors to assess our students, and this is a hard bar. Students must pass this assessment. We use tutors to second mark the borderlines and also the fails, but for the vast majority of the students, we go with the standardised assessments, and it works very well. Feasibility, cost, impact, well, you've got the details up there. It is very feasible. We've proved that, and you'll see where we're actually putting it into effect in the moment. The cost was actually really interesting. It cost us. We paid the simulated clients for their training and also for their time, but it was a lot cheaper than paying faculty or staff, even adjuncts, to mark these 250 videotapes. In addition, they became a kind of small community within the law school, and I'll say more about that in a moment or two. Impact was big there. Also on regulatory bodies, Law Society of Scotland was very interested in this, as was the SRA, as you'll see in a moment. And these now are the projects and where we have them all over the world. University of New Hampshire, I'll say more about that in a moment. We've got them in Australia, in Japan, in Ireland. We also have them in Hong Kong. and also in England, in London, and also Northumbria University Law School. Whole variety of projects, each of them kind of testing different aspects of the use of standardised clients, and particularly in their assessment role. If we look at New Hampshire, for example, you'll probably be aware of this, the Daniel Webster Scholars programme there. Standardised client was a key part of that, because it was part of the kind of assessment process by which the students were assessed within the simulations within the programme. Not the only form of simulation, but certainly an important part. And it was quite important for the Supreme Court of New Hampshire that things were done well, that this was a valid form of assessment as well, and that they could be assured of that too. If we go back and take another example there, the SRA, the Solicitors Regulation Authority for England and Wales, they're the regulators for solicitors in England and Wales. This one here is quite an interesting one, QLTS, the Qualifying Lawyers Transfer Scheme. About 2010, the SRA discovered that approximately 1/5 of lawyers coming into the profession were coming in through large law firms in London. In other words, solicitors who were coming in from abroad, they were resident in England and Wales, and they were doing a fairly simple paper and pencil test and getting into the profession that way. The SRA wanted to kind of draw much more of a line between that form of assessment and the domestic routes into the profession via degrees and the legal practice course and traineeship and so on, making them kind of much more aligned, as it were, certainly as far as the outcomes were concerned. And so what they did was they took the idea of the standardised clients that I'd worked with. I was on the working party there, along with others, practitioners, academics, and also medical educationalists as well as statisticians. And we put together this three-part assessment here, where knowledge was tested in the MCT there. There was what's called an OSCE. And then finally, there was a legal skills test, which I think in the last year or two has now been folded into the OSCE. Okay, what did the OSCE consist of, this objective, structured, clinical examination? Well, here it is here. There are 3 reserved areas, and there are components here, and basically the applicant lawyer will cycle through each of those. So effectively, the lawyer is doing 9 interviews, so that we can get some kind of validated results from that. There were a number of published articles on this by Eileen Fry from Kaplan. Kaplan got the contract from the SRA to host this assessment. What's unique about it as well is that it is an assessment without a course. And it also has no practice component to it. There's no practice demand, as it whether you be in practice for 5 or 10 or 15 years or whatever, which means that the assessment has to be really spot on. So basically what they found when they were analysing the results, and they used statistical measures there to prove it, was that using these as you can see here, these measures, Cronbach's alpha and standard measurement of error, they found that actually there was a really good quality coming out of that form of assessment. How did the standardised clients themselves do it? Again, they found really interesting results. That the standardised clients performed very well indeed. About 49 of them they were using in their assessments. So there was a high probability of variation there, but they managed to counteract that, which was really interesting. So this does work from a statistical point of view, but there are other and I think more profound aspects that come out of this form of assessment that we can draw from it. I think that first of all, this form of assessment really challenges the curriculum methods in the way that Lee Shulman is talking about when he talks about the hegemony of the signature pedagogy, and I'm talking about signature assessment methods. This sort of thing challenges it, because we focus on the ethics of the client counter much more directly in the situation that we have there. It also reveals the cognitive poverty of conventional law school assessment. And it also creates new categories of law school employment, because these people are coming into the law school fairly regularly. Sure, they're employed on a kind of an adjunct basis, but they're not really adjuncts. They're people that are doing new things in the law school. Above all, they're breaking the isolation of the law school. We're having ordinary people into the law school, and they are doing really important things. There's probably no more important part of our teaching and learning lives than assessment. And these guys are doing the really hard part. In addition, we can also link up clinic with ordinary classes, more conventional classes. That's exactly what happens in Northumbria, for example, where the fairly conventional first 2 years of a student is then linked via work such as with simulated clients in the third year to the mandatory clinic that they have in their fourth years. And they found that was a really helpful bridge from conventional into clinic work. And there's other things as well. For example, the role of the regulator changes quite subtly here, because the regulator, we would say, should really be encouraging innovation in this kind of radical reform, taking on board these sorts of things, looking at them in detail, and then kind of, asking other people to think about taking them on board. Okay, if we look now at learning from other jurisdictions, and in particular digital SIM assessment, we'll see the same sort of things happening there. Simple is a piece of software that we developed at Strathclyde. It cost us about £200,000. We got grants to do that. And what we did was create a pedagogy for the software so that one interacted really neatly with the other. We call it transactional learning, transactional in the Deweyan sense rather than in the specific kind of sense that you would use transactional, say, learning from transactions in your classes. But that apart, this is fairly easy to see what we're actually doing there. But how did it actually pan out in practice? Well, this is basically your kind of very stripped down case management system that we gave to students and staff so that they could interact with each other. We also, within the software, created a directory. We created a virtual town on the web, the town of Ardcalloch. This is the River Clyde here, stretching diagonally. So it lies on the south bank of the Clyde, where there's just green fields there at the moment, but actually there's a town, if you look close enough. And that town was the basis for these transactions here over 2 semesters, as you can see. There were smaller transactions going on there as well, but these were the really big ones. So we were asking students to learn through an entire programme, a postgraduate vocational programme that they had to go through if they wanted to become solicitors in Scotland, called the Diploma in Legal Practice. And in this diploma, they practice these transactions in firms, virtual firms, 4 students a firm. The firm was given a mark, generally speaking, though not always, not the individual students. So we were asking the students to collaborate there within the firms. In the personal injury project, for example, we set this assessment criteria, I think what you guys would call rubrics there. And what we were trying to do was to get them to focus on professional aspects and adapting the academic learning that they had learned in their undergraduate careers in the LLB to the specific transactions that they would be carrying out when they went into legal offices. And this is the sort of thing that we came up with here. This is what the students told us in their reflective reports that we asked the students to write, that they learned from this sort of transaction. Basically, in this transaction here, each transaction was slightly different, but in this one here, we didn't give the students any lectures. There were no tutorials. There were no workshops. There were voluntary workshops if they wanted to come to them. What we were trying to do was to sweep aside all the academic furniture of a curriculum and focus on the transaction, the simulation, the experiential learning itself. So this was a kind of problem-based learning over a long extended period. So there were lots of support mechanisms there for the students, but they could draw on them only if they needed them. What are we assessing in Simple, though, in those transactions? Well, these are the sorts of things that we're assessing. Quite a lot of, a whole variety of kind of knowledge items, I'm sure you would agree. but also skills. And what we were trying to do was to create a social space, which is a workspace, where you have learning and assessment, a bit like master and apprentice, where learning and assessment is actually linked, rather than having a period of learning, which we normally do, and then a period of assessment. So that kind of integration or fusion of the two was actually really important, because that's what happens to all of us in our lives. You know, the learning and the assessments are integrated much more in what we do. How were we going to assess them? And I'll go through each of these in just a bit more detail. Well, we could focus on tiny, discrete tasks. For example, if there were a document that they had to submit to a court, and the document had to be word perfect, or else the document would be bounced by the court, then that was really important. But moving to the more general, we could also assess the whole file plus a performative skill, perhaps. Advocacy, interviewing, whatever. Or we could have tasks in whole file, or task, file, and performative skill, as in litigation. And of course, that number 4 is by far the most complex. When we're talking about discrete tasks, we're really looking about setting the context in the task, and above all, designing feed forward and feedback. That was really important, because this is really a kind of a design task more than anything else. When you come to the second level there, we're looking at holistic assessment of a document chain, because we're looking at a whole transaction that the students would be assessed upon. So basically, we would ask maybe for critical point documents, but we would want to see the whole transaction available to us via the digital case management system. In 3, the tasks and the whole file, we would be looking at specific tasks, but also the task could shadow tutorial work, or maybe even precede tutorial work. So we kept our design quite flexible in that sort of a way, so that the students didn't get bored, and also so that the staff didn't get bored as well. And there was a variety there in what the students were actually doing. Of course, one key issue there is how many attempts at each task would we allow the students to have, because they have to learn, and very often they learn through feedback, but we don't want them endlessly attempting things. So that was always an issue for us, easily solved, but it was something we had to bear in mind. Plagiarism was very rarely an issue for us, because we set transactions which were based around a single spine, as it were. So in personal injury, for example, there would be an electrician from the University of Ardcalach who had tripped up, fallen downstairs, and wanted to claim against his employer. That was the same for all 280-odd students. But what we did was create the adversarial transactions by putting the details into a document server, so that the names, ages, and the addresses would change for each transaction. So that, for example, injuries would change, so quantum would change then in any specific transaction. We would also change details of, contributory negligence. So again, that would significantly kind of skew, as it were, or individualise the specific transaction. And that was really important, because the students then got the sense that they were working on something unique. So plagiarism just simply wasn't an issue. But at the same time, they could talk to each other over forums about, and we wanted that. We wanted collaborative learning not only within the firms, but also across the firms on one particular side of the adversarial transactions. Because we wanted, as I said before, the feedback, the feed forward, and the assessment to go hand in hand. Finally, 4, most complex, most authentic, and most demanding as well. So that was like 1 to 3 plus more. Performative skill, assessed in role, the sort of thing that you would do as a piece of advocacy, for example, in litigation civil procedure, where you take your documentation up to a certain point, and then you have to, via the simple case management system, with the other side, with witnesses perhaps, with court in court process, with court personnel, and then at some point or other you would appear before the decision maker, the sheriff, who would be then assessing the student's performance. So what we're really talking about here is interleaving learning support and assessment. And as I've said before, there's a PI project. Quite interesting point there, the surgery mentor, instead of having workshops or tutorials, what we did have were voluntary surgeries. And these were not hour-long or 2-hour-long, they were just 15 minutes, literally like a doctor's surgery. And they were voluntary, so if the students were genuinely stuck and they couldn't see anything on the web that would actually take them forward in terms of the pretty considerable resources that we gave the students on the web, then they could kind of put their hands up virtually and say, help. And then they would take their problems to a specific tutor, very often a practitioner as well. But the practitioner, we trained not to give lectures, not to even hold tutorials, but simply to be there in order to listen to what the students were saying and help the students, much as PBL, problem-based learning facilitators, are trained to do, and help them to resolve the difficulty that they found themselves in. That's much more helpful, obviously, than telling war stories or whatever. Okay, some little examples here, because one of the last points there that I'm talking about is that this support that we gave them was also via something called practice management, which was a little module that ran throughout the whole course and was really important, because very often students will have difficulties when they're working with each other in their firm. What would we then do if students were having those difficulties, maybe of personality clashes or freeloading or issues with people being absent through sickness and all the rest of it? Well, what we did was have a coach, as it were, called practice manager. And the practice manager or coach to the firm would then effectively help to mediate any difficulties that the students had. But in addition, would also be coaching the students in what it was to be part of a firm and what practice management and management of the firm was all about. That was a really important part of this whole kind of environment for us. And again, it's not so much mentoring as coaching that we're talking about there. Mentoring may be something different. Here is an example of one environment we put together where the students have their intra-firm forum there. They've got their own calendar for their own use. They have an activity log where they log their activities, not a billable hours, because we didn't want to kind of get down the road of billable hours itself, but certainly we needed an activity log for each student. So the students logged their activities there with any notes that they wanted to make. We also gave them a personal log as well if they wanted to contact their practice manager privately to discuss anything. In addition, we gave the students the activity logs to see, so the firm could then see. That was really important because the firm was actually assessing every week. They were assessing themselves, the individuals, but they were also assessing each other's work in peer review, and that was really important as well. And that was fed back to the practice manager each week. So that we would have the practice manager, and this is the practice manager's view at the moment, could look at this firm and could see who was working on what throughout the course of the transactions. For example, practice management tutor here. This is an entry sent there on private client, wills, trust executaries, that sort of thing. Now, this is what we did in Strathclyde. We've taken this forward and significantly improved the whole thing in ANU. We made it a lot larger as well. It's scaled up to approximately 1,300 students, I think, this year on the graduate diploma in legal practice, same name as in Scotland. That is in Australia. And basically, the students who are working on that are working through a version of Simple called VOS, the virtual office space, with more or less the same functionality, but a different interface, and with much more in the way of management tools as well. This slide's from Annika and Liz, one of the two members of staff who are working on this, on the practice management side of this in Australia. We're also building that into a body of theory that some people are working on. For example, Mary Gentile's idea of giving voice to values. That's really important from a kind of ethical point of view as well. And we have Vivian and Liz and others there working on that, ties into the whole kind of student distress and well-being literature as well, because we want to emphasize this as a mode, as a way of kind of combating the anxiety, the alienation, the isolation that a lot of students feel when they're learning along, which contributes to the poor results that we all know about. Is it feasible? How much does it cost? What impact? The cost of it is pretty huge, but we are, in terms of the spike of creating the software. But as you guys know already, because I heard you talking about the Walters Kluwer simulations that you're running and so on, if there's ways around that, and there are ways around that, then what you've got there is the ability to create transactions that can be run again and again, updated, of course, rehashed, but once you've got the actual, as you know yourself, the pedagogic framework, and you're okay with that framework, then that's the really important thing. You can then run different simulations, and you get the confidence in doing that. As for the impact, it was big, really big. Our students really liked that. The trainee firms, in Strathclyde, for example, where our students went into, they always remarked that our students were really good at transactional learning. They were also good at handling clients because we took them through the assessment and lots of kind of practice as well with the standardised clients. One interesting thing that we never really quite got round to in Strathclyde was to actually merge standardised clients with Simple. So we would have the virtual simulation and we would have the face-to-face simulation as well. And that's something that we're working on at ANU, where their graduate diploma in legal practice is almost entirely online. And so what we're trying to do there is to make our standardised clients, online, so that the interview takes place online as well, which is a significantly different step from doing it kind of face-to-face. It's one of the innovations that we're kind of layering on top of this whole idea of standardised clients. But then integrating that with VOS, with the virtual office space, and having that client available via a cell phone or a mobile phone. Okay, one final point here, and I want to just leave it there because time is moving on and we've got a bit less than 5 minutes left. What I call extreme law schooling, which is kind of forms of slightly out there curriculum design or methodologies and so on. And I think that in assessment terms, I think one of the things that's really interesting me at the moment is what we're doing at ANU, where we're putting together a new JD program, which is entirely PBL, problem-based learning. And we're doing that online. What we're trying to do there is to create a new program, which is available to students throughout Australia and possibly beyond as well. Why do we do this? Well, throughout Australia, most law schools, not all, but I think most, have a JD program. They already have LOB programs, but they've taken on the American model of the JD, and they do lots of interesting, innovative things with that. Generally speaking, face-to-face, sometimes a heavy component of online learning there. But I think this is a world first. I don't think anybody is trying, or maybe foolhardy enough, to put together a PBL environment with online learning. PBL, as you know, is derives from medical education. It has its own pedagogy and is based around the idea of cycles of problems which are solved by the students. And again, rather like the personal injury, there are problems, and around the problems you array the resources that the students would use in order to solve those problems. So, for example, in the first of, say, 2 sessions in a PBL environment, what you would have is a session where the students group together, probably 5 students online with 1 trained PBL facilitator, and the facilitator will probably be an adjunct. During that session, there is discussion. The facilitator largely remains in the background, the students discuss themselves, and the students set their own learning outcomes. That is absolutely critical. So they have an honest discussion about what they know and what they don't know, about the problem that's set out in front of them. And then they plan also their work. Who is going to do what at the wrap-up session? And then the facilitator at the second session after, and we can have kind of individual points where there's all sorts of resources available to the student in terms of the facilitator or maybe lecturers, possibly webcasts, podcasts and so on there as well. But at the second session, the students then come back and they report back on those learning outcomes and they display their learning on the particular learning outcomes for the problem. What's interesting about this is that it's student-centred learning. It is also student-centred assessment too. There's one other place, I think there's only one law school in England actually, which has a PBL curriculum, and that's York. It's face-to-face though, not online. But what's interesting about their assessment is that they have exams there, but I did hear that the first half of their exam consists of a problem which has already been discussed and dealt with by the students and the facilitators, and that's worth, I think, 50%. And the other 50% is an unseen problem which students are expected to analyse in the way that they would as if they were doing PBL. Quite a fascinating assessment there because it draws on the students' experience in the learning, brings the learning right into the assessment room, but at the same time make sure that the students are actually doing the work. So they're revising, they're covering the work of the class. They're also learning new things, as it were, in the examination hall itself. What we're doing here is we're also in our JD we're clustering the subjects. So rather than having silos of different subjects, say torts and litigation separately, we're integrating those subjects so that the problems can stretch across 2, possibly even 3, a tri-cluster, 3 areas of law. And that is something that we're working on with staff. Staff are hugely enthusiastic about this. I wasn't too sure whether it would happen that way, but they are. And they see that as a kind of, in many respects, I suppose, breaking the logjam of what they're already doing in terms of the LLB, and a really interesting experiment. But of course, it also means that what we have to do here is to put together the environment, as it were, for the students online. So we can't rely on environments that are out there already. We're going to have to rely on different environments, put together the environments ourselves for resources and also for communication between the students in the small groups, between the students and staff, between the students and the facilitators. So there's lots of things that have to be designed from scratch there, which makes for an exhilarating project. But it's the pedagogy itself based on problems rather than on knowledge items per se, which is really making us rethink not only teaching and learning, but also assessment. But in addition, what's really interesting about this is that we're able to move from the academic to the professional as well, because we're using the first 2 years to cover the qualifying subjects, but in the third year of the JD, taking it as a kind of like a block, though most students we imagine will do it part-time. They will study at master's level. They will be able to do the graduate diploma in legal practice, which is the qualification to enable them to become lawyers in Australia if they want. Or they'll be studying other master's options. It's ANU based in Canberra, so there'll be lots of policy options, for example, government options there as well. So there we have it. In terms of assessment, on that, we're thinking of integrative assessments, exams that embed course elements, but we're also thinking about evaluation where the formative becomes the new summative, as it were, and that's really important for us, where we fuse the two of them together, and also where we bring in social justice and ethics threaded throughout the entire programme, which is possible to do because you are redesigning from scratch. The heart of that is the problems. So what you're really building in there are the capacity or the spaces, the clearings in the forest, as it were, for ethics and justice to be discussed in those spaces. Okay, that's about me, folks. These slides you will find up on my blog there, paulmaharg.com/slides, and you can download them from there. I don't know if we've got any time for questions or whatever, but if we don't, thank you very much for listening to me. It's been a pleasure talking to you. Thanks very much.